please, Your Honour, my name is Kristen Thiel, and today I will be presenting the defence submission for Miss Lydia Stone. As it stands, Miss Stone is charged with acts intended to cause grievous bodily harm, in accordance with Section 317 of the Criminal Code Act, Queensland. This crime is liable to a sentence of imprisonment for life in accordance with the Penalties and Sentences Act. This submission, Your Honour, is to lessen that sentence. Firstly, Your Honour, it should be addressed that life imprisonment is and should be a last resort punishment, as in accordance with parsimony. An alternative is provided in the Penalties and Sentences Act, Section 153, that a person may receive a lesser sentence or be ordered to pay a fine in addition to or instead of. Your Honour, while a fine is applicable, Ms. Stone's financial position is dependent on a disability pension due to her blindness. She does not currently work for an income, nor does she own property, instead living in a rented property. Section 48 of the Penalties and Sentences Act states that an offender's financial position must be considered. In this case, it seems unreasonable for Miss Lydia to pay a fine for the crime, due to the reliance on a disability pension and really no assets. Your Honour, with fines being out of reach, I instead present the idea that Miss Lydia Stone receives an intensive correction order as per the Penalties and Sentences Act, Section 112. Miss Stone is clearly impacted by mental health issues in one way or another, due to a history of child abuse and the abusive nature of this relationship. Miss Stone clearly had a lack of ability to deal with her emotions, turning to physical reactions and alcohol as treatment. Without condoning her actions, it is easy to understand how this behaviour may have seemed reasonable to Lydia in the moment, likely being the only way she thought fine to deal with this conflict. She was being abused just as much as the victim was abused by her. This likely deteriorated her mental state and made her judgment and changed her judgment. Your Honour, Miss Stone had no prior convictions to this matter. She was a volunteer at a community group, with numerous written references attesting to her behaviour. She was described in a positive manner, with the people closest to her saying this act was out of character. Your Honour, I understand that good character is less mitigating in first-time cases, as per R and Kennedy, but R and Gent instead states that both lack of prior conviction and good behaviour is evidence of good character. Having no prior convictions and evidence of good behaviour together demonstrates a long-standing good nature. Evidence of her good character shows this incident is isolated from her usual demeanour, thus putting her less at risk of reoffending, as demonstrated in Ryan and the Queen. Turning back to her mental health, this may explain the isolated nature of this incident. While no mental health diagnosis has been made, the specification of mental illness is less relevant than the effect the mental health had at the time Lydia committed the crime. R. Verdens establishes that a person's mental health may be mitigating based on moral culpability. Miss Stone is clearly a mentally ill person, with a lack of ability to react appropriately to trauma and abuse. Her moral culpability is arguable, as in her perspective, this behaviour is normal. In some circumstances, this sort of mental impairment may lead to reoffending, but it is clear this incident was targeted at her alleged abuser. Thus, she is unlikely to continue this pattern of behaviour. She has likely witnessed this violence as normal relationship behaviour, impairing her judgment in this situation. Your Honour, I am aware intoxication does not diminish the crime. However, Miss Stone is a known alcoholic. Her constant abuse of the substance has likely also impaired her ability to make good judgment, and likely contributed to the decision of committing the crime. Your Honour, I would like now to address the matter of confession. Miss Stone, the day following the crime, went to the police and confessed to the crime. This action meant a cease in further criminal activity by her, and while she may not have communicated it, a sense of remorse from her actions is displayed by admitting to the crime. It is commonly accepted that a crime confession leads to a sentence reduction due to it saving time not only by the police but the whole due process. It also prevents multiple offences being committed by Miss Stone. Miss Stone has demonstrated in her confession an understanding that her actions now have a consequence. Following this confession, Your Honour, she openly pled guilty to the charge of intent to cause grievous bodily harm and did not hesitate in entering this plea. A guilty plea is an Australian-wide accepted mitigating factor used for sentence reduction due to encouragement it has on more people pleading guilty to crimes they're guilty of. Her willingness to accept this charge indicates the belief that she thinks this charge is correct, and her cooperation in the process of justice indicates that she's accepting of this charge. It should also be noted, Your Honour, that her quickness in entering the guilty plea should be considered in her sentencing, as it did save time. Your Honour, my final point is her rehabilitation prospects. As established, Miss Stone has no prior convictions and a history of good behaviour. This is further demonstrated by compliance with her bailment conditions and overall compliance with the proceedings. This is also demonstrated by references from her community groups. She has demonstrated her good behaviour time and time again throughout this. Miss Stone is a sick woman, suffering with alcoholism and some sort of mental illness. She has lived through child abuse and clearly an abusive relationship. Miss Stone has expressed her lack of fear of prison, meaning that it may not have the impact we are wanting it to have. These factors indicate a prison sentence is not going to support her rehabilitation, but likely hinder it, making it take her longer to be a productive member of society again. The court should instead mandate treatment for her mental health, alcoholism, and likely trauma from this violent relationship. Thus coming back to my first point of considering a of considering a